Hello everyone. Welcome to this evening's discussion on the marriage equality judgment, hosted here at the Vidhi Center, Delhi office. Those of you online, welcome to you as well. I hope I'm audible and everything's all right. If there's any issue, please send a message on the chat and we will work on it. I guess we're running a little late, so I'll get started. Recently, the Supreme Court passed a judgment on the question of queer marriage. And those who, especially those who are in the queer community, but especially for those who are outside the community, the journey of queer rights in India seems to have been somewhat one that looks like it's punctuated by these judgments every few years. That's what it looks like to anybody who's not actually in person familiar with queer persons or with the community or with the movement. There was a judgment in 2009 from the Delhi High Court about intimate relationships and sexual conduct amongst queer persons. There was a judgment from the Supreme Court overruling that in 2013. 5 years later, in 2018, that same judgment was overruled by a five-judge bench. And now again, a few years later, we have a judgment on queer marriage, suggesting that while queer persons have every right about relationships, intimacy, and autonomy, they do not have the freedom to marry. Yes, while this is the story that people see when they look at it from the surface, we want to have a discussion today that is more about joining this legal journey, this very facially legal journey, with one that is more real and down to earth, about the individuals who are really going to live these queer lives and be subject to these laws. And we hope that today's conversation can be about that, bringing this home to not just queer people, but also people outside the community. We have with us today an amazing set of panelists. In fact, so stellar are these panelists that we had to have not one, but two moderators. And along with me, Lalit Panda, we have my fabulous co-host, Namrata, and she'll be taking it forward from here. Namrata.
Hi, good evening, everyone. Thank you for joining us today. I'll just take a couple of minutes to introduce our panelists and then tell you about the structure of today's conversation before we open the panel. We are joined today by Saurabh Kirpal, who's a senior advocate at Delhi High Court. We're joined online by Akkai Padmashali, who is a transgender rights activist and the founder of Ondede. She was also a petitioner in the marriage equality matter. And finally, we will be joined soon by Gopal Sankaranarayanan, who is a senior advocate with the Supreme Court of India. Thank you so much for taking the time to join us on a Friday evening when the AQI has shot through the roof, but you've decided to come here. And we look forward to your reflections as we proceed. In terms of structure, we will broadly be focusing upon three themes: initial reactions and responses to the judgment and the immediate impact on the queer community. We will then move on to an assessment of the judgment itself, where we will be reflecting upon the legal reasoning, the merits, the demerits, the premises that the Supreme Court relied upon when denying marriage equality. And finally, we hope to conclude on a positive note, the way forward. What do we do with what we have, and how can the movement, in terms of not just civil society, but lawyers, take this journey forward and fight for expansion of civil and political rights of queer people in India? So without further ado, I'm so sorry. For those of you who are in the audience in person, we will be opening the floor to questions at the end. Please do raise your hand and introduce yourself. And for those of you joining online, please share your question over chat. So without further ado, Saurabh, I just wanted to open with you. I'm assuming you were in court as the judgment was being delivered. So I was wondering what your immediate response to the judgment was, especially once we had clarity about outcome. And how do you think this is going to impact the queer community in India?
Well, I was there for all 2 hours of the delivery of a rather long verdict, longest of which was pronounced by Justice Chandrachud, Chief Justice, who's the minority. And I think there's something to be said about pronouncement of judgments also, that you must, it's not like a detective novel that you have to wait till the end to figure out what it is. You're dealing with people's lives, right? So just like rip off that band-aid. We waited 6 months already for the judgment. So it was a bit strange the way they went about the whole pronouncement aspect of it. But I suppose that's tradition. But surely they could have initially accepted what's happening. That would have lessened the pain. But I think during the course of reading of the judgment, it was fairly obvious what was happening. Because the moment the first two judgments came and Justice Kohli did not sign either of the two judgments, and Justice Bhatt started reading and saying Justice Narasimha's concurring opinion, we knew the writing was on the wall as to what it was. And you asked me what my initial reaction was. And, I've had PTSD since the time it was announced till a few days ago. So I've really not been able to fully come to terms as to what my emotional reaction to that was. You work on an intellectual level because you're lawyers. And of course, in this, I'm wearing two separate hats. One is as a lawyer who argue the matter, but also as a member of the queer community, it has a very deep significance to me. Not only in terms of what the judgment means in the larger context of queer rights, but also for me personally, as to how it entitles and enables me to live a full life with a person of my choosing, a person with whom I have lived for 22 years, which the court declared was just a friend of mine. A person with whom I have a right to a relationship, but that right to relationship only means I can have a giant party to celebrate whatever the court thinks we do to celebrate. I really sometimes wonder about Justice Bhatt saying, "Oh, there's a cause of celebration. You can celebrate. What does he think we're going to do?" So, but the initial after the shock wore off, because we were also led up a bit of a garden path in this whole hearing. The way the matter was expedited, the way the hearings began. There was an expectation, and I don't think I'm alone in that we had a perception that this was the time, that at least something would be done. So I think this was a bit of a edging experience for us, for those who can get it. But the initial reaction, of course, was shock, followed by a deep, deep sadness, actually more than anything else. Sadness because it was so personal, and I felt let down. And I was sitting in court, and these 5 judges sitting there pronouncing verdicts. They all know who we are, not just me, my other colleagues. Entire queer bar entire queer bar, a very large number of queer people were in court for pronouncement. You could see a bit of shiftiness in the pronouncement, or maybe just I was reading it. Because for me, it was as though the court had let us all down. I'm not talking of really now the legal aspect of it. We'll come to it. We have someone who knows a bit of the law. And we shall discuss that eventually. But I'm speaking now purely personally on this matter. I felt as though these people knew me. And they talked and waxed eloquent through the pronouncement of this judgment about how difficult life was. Yes, life is difficult for us. But that's why we came to you. And it was as though it was one platitude after the other. It was almost condescending in a manner. So I felt first shock, then disgust, coupled with irritation. And I'm running out of adjectives, all the negative feelings I had, because I really felt more than anything else, the court had not stepped up to do what it had promised us it would do. So that's my initial feeling actually when the verdict came out. And I couldn't even bring myself to read the judgment for the first 4 or 5 days. It was so traumatic. But then I agreed to write an article, and it's usually a good idea to read the judgment. Not always. You'll be surprised at some of the stuff that you read. So I brought myself to read it, and it was a slow, painful process because each word there hurt me, especially when they said that what we discussed the specifics of it. So it was a painful experience for me more than anything else. And I still feel let down. They just didn't do what they promised they would. They just didn't do what they could do. And they certainly did not do what the Constitution required them to do.
My apologies for being I was in court and I just finished before one of the pontificating judges. And I just came. I understand. I missed the question, but I'm presuming it's as you indicated about initial reaction.
Initial reactions, thoughts, and impact on the queer community.
And
an impact on the queer community.
Impact on the queer community. Okay. So Actually, I was called the previous evening by something from the Express saying, will you write a piece once the judgment comes out? I said, okay, I don't write on matters in which I have participated. This is one which I did not participate. So I said, okay. And I was waiting for the judgment to come out because, it just started. And as Saurabh said, it just went on for a while. And I was sitting actually outside far away and I was looking at updates, which my juniors were sending me from inside court, trying to figure out what was happening. And I was sitting coincidentally with Sham Devan. But Sham Devan's brother has been at the forefront of much of what the queer community has done for many years, for more than 20 years. And on his family group, Vivek was sharing updates as well. So I had my updates, he had his, and we were sitting next to each other and chatting about it. And we said, look, it sounded good. And I'm just telling you because I can imagine how tough it must have been for Saurabh and the others from the community directly. And I feel as much as Saurabh felt directly, I felt exactly the same way. I felt there was deceit. I'm sorry to use a strong word, in the manner in which it was carried out. Because if you know you're in the minority, when you start delivering that verdict, the least that one expects is you just cut through and just tell us at the beginning that, look, this is how we are split, and I'm going to start reading. There was no indication of any of that. So, especially if you're going to be in the minority, don't spend 2 hours of a court day reading out the minority judgment. This is really pontification, which has no legal effect eventually, as you would realize at the end of the judgment. So we had all these observations, these platitudes, which unrolled over about almost an hour and a half of it. And one was optimistic, waiting for the conclusions, and then that little bit about right to marriage not being a fundamental right, and we're trying to figure out where that is segueing. Because I don't know the data. I haven't followed the arguments. I only have a printed judgment, which I had about an hour and 45 minutes to go through to churn up that article in the evening. So I don't know the background. Saurabh knows. He was there in court. He argued. He was present through all of it. So I couldn't find out what the connection was. Why are you getting into this issue? Where are we going if you're saying it's not a fundamental right? I mean, what's the point of? And then there were those conclusions. And eventually, I think one of those expressions which I asked him, he said, us. What does he mean, us? Who's joining in the us? And then, of course, we found out that this was the entire minority judgment going on. So for me, I think, without going further, huge amount of disappointment. I thought this was an opportunity for the court to behave as an independent protector of our rights, and they didn't behave as that. We have found for cases with possibly lesser consequences and lesser civil impacts that the courts have gone much further. They've, of course, gone much further at a point of time when our court had a collective stronger spine than it does now. I didn't find that replicated. We were hopeful, we were optimistic, especially we were hopeful. I remember commenting to somebody that if we had to count 5 judges in the last 30 years, we would be very happy with these 5. We would say, hey, this is good. We know the philosophy is, fairly liberal leaning. I mean, if we can't get it from these 5, where are you going to get it from? I thought generally, and that's what I expressed later, I thought they could have done much more for the community. They could have molded reliefs. They could have been very clear in that direction. And I'm very surprised about the way the majority, copped out and I think shrank back from a challenge. Is this being recorded?
Yeah.
Okay.
Yeah.
Should I care? Oh, no, the reason is I keep wondering, I think all you've written about this as well. The court as a political institution, right? Sometimes I wonder, is this one judgment possibly a swap for something else they're going to do? I don't like to think that way, and I imagine it's not. I don't know if it is, but I keep wondering. Well, my initial thought was, well, if they've done this, maybe 370 will go well. Right? Like there's a case we will say, because if you look at it from the outside, we're looking at a situation where you can't have so many judgments. This was possibly a judgment where it wouldn't matter to the government particularly that much. 370 is going to matter a lot to the government. Electoral bonds is going to matter a lot. These are cases which are, it's been tenuous and going on for a long time. So I keep wondering, is it part of a larger fabric? Is it an idea? Because it's not going to look good for this court. It isn't looking good for this court. That when you got an opportunity which has been waiting several generations, that you're going to make them wait for years more and just forward off to the legislature. But I'll stop. That's what my thoughts were.
Thank you, Gopal. Turning to you, Akkai, you had written a letter to the Prime Minister along with several other activists expressing your disappointment with the judgment and speaking about the necessity of making marriage equality happen. So if you could share your initial thoughts, your reaction, and also the conversations that have been happening in the community and the impact that's felt by queer people.
First of all, thank you, Vidhi Legal Center, for converging all of us together to speak this important issue, which is unspoken. And I'm sitting next to Habida Begum, who is born intersex. She's also the president of the Karnataka Intersex Association. She's from a very rural village, from the North Karnataka. And my name is Akkai Padmashali. I am part of the social justice movement, more than 25 years working for justice. That's why we say people like Saurabh Kirpal should be part of the judiciary. Knowing that he belongs to the gender and sexuality minority community, I feel so ashamed. I feel so disappointed. Not only Akkai, the whole country and the whole world. Knowing that we are part of the largest democracy, and this largest democracy is a system of majoritarian, is a system of totalitarian. When I even say this, it is a construct of a social notionized, it's a patriarchal institution and society that we are living, so much of culturalized, which is not in favor of any sort of intersex, gender and sexuality minorities of this entire existing, the country's politics. I feel so ashamed the judgment came. Very disappointed, as I mentioned. The judgment is is out. How many women's movements have spoken really of their voices? How many social justice movements have spoken their voices? The human rights defenders, the Dalit voices, the most the marginal sections of society, the United Nations, Human Rights Council, not even come out with any sort of statement. So this has disrespected the system of justice. And what happens to my Indian culture mythology stories? We keep referring to Khajuraho sculptures. We keep referring to Bhagavad Gita's Ramayana Mahabharata stories. We're talking about the Pope Francis statements. And where are these stories and statements has gone? I want to remember Justice Indu Malhotra, the 2018 judgment on the section 377, knowing that we were criminals, we were decriminals, we were recriminals, and we were no more criminals, made by the same constitutional bench of this country. And Justice Indu Malhotra says, history needs to owe an apology for the movement of sexual minorities and their families. And the same statement has been disrespected by my Indian judiciary, which is very much disappointing to all of us. And especially the working class, the non-English speaking people, the poorest of the poor, who are really in the process of understanding their gender, understanding their sex, understanding their orientation, understanding what is sambandha, means the relationships. I can't be forced to be a man. I can't force me to be a lesbian woman or a bisexual, man, whatever. It's about the personal choices. I think until we address this issue, I think when the judgment came, the whole country was so stunned. Did not have any voice to speak about this, knowing that the Justice Chandrachud is part of so much of it, especially the Constitution bench. As a community, we had a vast amount of trust on the judiciary, at least talking something, some rights for sexual minorities. And that judgment, we have seen how it has been disrespected my identity, disrespected my sexuality, disrespected my relationships. I think it's a way long to all of us. And I also want to say here, in the page number 84, the judgment has quoted Akkai Padmashali. For this, I only want to thank the Constitution bench of this country. At least some recognition has been brought to this judgment. And also the judgment is so narrow in its kind. Transgender woman can marry a cis man. Transgender man can marry a cis woman. So what if Akkai is a transgender woman attracted to another transgender woman, then bisexuality becomes a transgender lesbian woman. So I'm not supposed to rise in love, not fall in love. So how do you bring up these concepts, these concerns? How do we educate my system of justice on the very basic understanding of what is sex, what is gender, what is sexuality? I am done, Namrata.
I guess we're at that part of the conversation where we want to talk not just about what the judgment was, what it felt like, but also whether it was just, whether it was correct in what it said. And I want to go back to you, Akkai, for this. The judgment had several different questions that it was dealing with. Questions about freedom, about the right to marry, and it denied a right to marry not just to queer people, but a fundamental right to marry to all Indians. And on the question of just equality, about treating queer persons who want to get married on par with non-queer persons who want to get married, its understanding of that question as well was that maybe there is some benefits, not just marriage, but benefits from marriage, where there should be equality, but the court can't do anything about it. And in many ways, even their argument about the right to marry is very mixed and confusing. Akkai, as someone who isn't trained in law, I want to start with you. I want to ask you a little bit about, you've seen a little bit about, you've read a little bit about the reasoning that the court had in mind. The things that it suggested were the reasons why they can't provide a right to marry to queer persons. Is there anything in these reasons that really jumped out at you, that really struck you as something that anyone, not even lawyers, but even non-lawyers, can appreciate would be incorrect law? Because I really want to understand what queer persons who are not from the law, not from a legal background, how are they thinking about this judgment, about its real reasoning? Is there something that you'd like to say about it?
Yeah. See, when the section 377 from 1860-61 to 2009, we were criminals before this country. And we were above the law, we were below the law. How we were above the law? The law was so conservative, from such a colonial perspective, was given the legitimate, the legitimacy to have a so-called cis man, cis women with penis and vagina can perform sex for procreation. Apart from procreation, any sex that was done, that sex was considered against the order of nature. So means then, that point of time only, we were above the law. Below the law, we were criminals. You get it? So understanding these consequences as a community, we are existing definitely as part of India. We have our culture, we have our tradition, not from the context of patriarchal notion. My existence is my culture. My identity is my culture. My sexuality is my culture. If the system of majority is not understanding, I am not the wrong person here. Even the judgment which has referred to the parliament, I think the court has done a mistake on this. Even in the parliament, how many members of parliamentarians are well educated to speak on the politics of sex, gender, sexuality? And where are my people as representatives in Lok Sabha, in Raj Sabha, in Assembly, in Council? I can't even find one, except Shashi Tharoor, except D.K. Shivakumar, except Veerappa Moily. And how many political parties came out in support of this judgment or against this judgment? Except CPI, Sitaram Yechuri gave a statement. Congress Jairam Ramesh gave a very neutral statement. So this is really not in favor of the movement. But as communities, we had so much of trust on the judiciary. Go back to 2009, July 2nd, Delhi High Court judgment was in favor of the movement. 2013, the 11, 12, 13 judgment was disrespecting the politics of identity and sexuality. The 2014 NASA judgment upheld the dignity of transgender people. The 2018 judgment was very supportive for the movement. But 2023 was so disappointing. And I feel that we are again recriminalized here. And also I want to question back the system. Who gave you the power What made you to decide on one section of society? Whether you give judgment, whether you don't give judgment, I feel so proud for what I am today. Whether I have right to marry, I don't have right to marry, that is none of its business. I am a human being. I also have sexual feelings. I will keep marrying. I'll keep divorcing. Everything is my right. And you have no right to decide my identity.
Thank you. Thank you so much. I think that really gives us a perspective on when people talk of a principle in law like separation of powers, what the expectations from individuals who really have to deal with this abstract highfalutin principle, how they actually feel about it. Yes, so I wanted to turn to Gopal first and then Saurabh. There are numerous legal questions that are engaged with by the judges in the course of the judgment. I wanted to ask you to unpack it, to try out a little bit to unpack it, to try and make it accessible for people who maybe are not coming from the law. These questions about what does it mean to recognize a right to marry, a freedom, so to speak, a liberty. What does it mean to say that somebody is free to marry? And for the government to then recognize that marriage. The question of separation of powers that supposedly comes in here, which is that you have a law recognizing some people's marriages. Are you obligated to recognize the marriage of other people? In what situations? What would be the fear of judges who think that is to rule, to direct the government that you now have to recognize the marriage of queer people? What would be, let's just say, what would be the fear of a judge to think that if I direct this, if I ask the government to do this, it might step over and allow for some kind of bad consequences that now in the future courts will be able to ask anything and everything. There be something like that, or you feel that's entirely wrong? And lastly, there is, and Saurabh is actually, we've been discussing about discrimination law a lot. There is a lot in this judgment that speaks to the question of discrimination under Article 15, child discrimination. And it seems the judges, Justice Bhatt and Chief Justice, were in some kind of disagreement about what discrimination means in this situation, whether positive obligations meaning requiring the government to do something new, whether that can be done under Article 15. So Gopal, as somebody who's not on the petitions, first from you.
Yeah, I actually wanted, if it's okay, for Saurabh to answer first. Because, and I'll tell you the reason, because I understood during arguments that there were a lot of technical objections that were being taken by Tushar Mehta, Kapil. So again? Okay.
Yeah.
Lots of technical objections that I understood that were taken by Tushar Mehta, Kapil Sibal, etc., who were appearing against us.
This one's good.
Can you hear me? Yeah. Yeah. So there were lots of technical objections which I was not privy to, which I heard made, trying to create stumbling blocks if the court wanted to do something about marriage for the LGBTQ community there. So I didn't know what those objections were, and I would have thought they couldn't be something to overwhelm or scare the judges, as it were. So if Saurabh could share that, then I'll react once he's done.
Of course, sure.
Right. So what I'll try to do is first a short synopsis of the arguments were and how the courts dealt with. I think that's kind of important because I believe fundamentally what the court has done is to take a simple question, convert it into a very complicated question, and then fail to answer it. Right. So there are multiple problems with the judgment. So the argument was fairly simple, that there exists a social legal institution called marriage. That marriage is limited to heterosexual couples. Exclusion of same-sex or non-heterosexual couples from that social legal institution is discriminatory. And therefore, please either strike down the act because it's violative of Article 14 or uphold the act by adequately reading into its various provisions such kind of a right to marry between non-heterosexual people. If you can't do that, at the very least, say that there is a fundamental right to marry which is the second argument. Even if you don't have the Special Marriage Act, you cannot do something with the language of that act because it does not lend itself to apply to a non-heterosexual couple very easily. You have to then recognize that there is a fundamental right to marry between any two people. We thought that was a fairly non-controversial point. Multiple judgments of the courts said that there is a fundamental right to marry. In a case involving a Muslim woman and a Hindu man, in intercaste marriages, the court had taken a view that there is a fundamental right to marry. And I think most people, lawyers or lay people otherwise, would find this fairly unobjectionable and fairly obvious. So we said once you have a right to marry, then there is an obligation upon the state to ensure that the right to marry is recognized. And that right to marry, of course, is what is called an unenumerated right. So it's not clear from the Constitution, but from a reading of various provisions, particularly Article 21, you would read that right into the Constitution and then recognize it. And if you cannot actualize it, at the least you give a declaration to the effect that that right exists, and then either direction to the court, to the parliament, or to various authorities to do something about it. At least make that positive declaration. So what the court does is, in terms of the first question of discrimination, there are three separate views that are taken by the courts. Justice Cole says yes, it is discriminatory to strike down the act. Chief Justice Chandrachud does almost a cop out here. He says that if we were to read this act and find it discriminatory, we would have to strike it down. We don't want to strike it down because that will have devastating consequences. One can agree with him on that one. But he says that there is no way I can also read into to the act so as to make it workable, so that the act would then apply to non-heterosexual people. Therefore, I won't consider as to whether it's really discriminatory or not. So there is really no determination. Now, immediately one problem with that is that it's a template for future parliaments to come and start enacting legislation, which will be so complicated, favoring one side, that the moment you strike it down, you can't strike it down because there are devastating consequences, but you can't read into that act something else, and therefore discrimination will continue. It is as though an Article 31D to our Constitution has been added, which is a complexity article, right? We have 31A, B, C, which are schedules from fundamental rights chapters to our Constitution. Now we have legislative fundamental rights exclusion. So that's something very technical. We can talk about it if need be. So that was on the question of discrimination of Justice Chandrachud. What's peculiar is the finding of the majority, which is that the Special Marriage Act is not discriminatory at all by adopting only an Article 14 analysis. The very traditional Anvarele Sarkar, intelligible differentia, and national nexus to the objects ought to be attained, right? This was maybe fine in 1950. I had thought the jurisprudence of this country had moved on. Now, there are multiple people and legal scholars who will disagree with the manifest arbitrariness test, etc., and there are problems with it. But the fact is, we were not in an academic setting. We were in court. And the court has, in Shaira Bano's case, accepted the principle of manifest arbitrariness. So there was no cause for the court to say, I will not apply its manifest arbitrariness test, but instead let me go back to the hackneyed, much derided twin test, I would say, of Article 14. But they chose not to address the manifest arbitrariness aspect, said that the object of the Special Marriage Act was only to recognize heterosexual marriages of intercaste and intercommunity people, lifting yourself up from bootstraps virtually, because you conflicted the object with the rationale, with what your classification was. So, and that's something, a point that Justice Cole notes in his judgment. So that is the error in terms of Justice Bhatt's decision on the discriminatory aspect of failure to recognize non-heterosexual marriages under the Special Marriage Act. To me, really, ultimately, as a citizen, the most shocking part has been the failure to recognize a right to marry. How The unanimous verdict, and the reasoning is different for the various judges as to why they've come to this idea that there's no fundamental right to marry. But let's just address what the majority says. That the court cannot create a social institution because that social institution existed before the Constitution. Because marriage predates the Constitution, therefore it cannot possibly be a constitutional right. Now, there is no judgment cited to this effect, partly because it's an absurd argument, right? Just because something predates the Constitution doesn't mean it can't find mention in the unenumerated rights section of the Constitution. Multiple rights are not mentioned, predate the Constitution. The right to privacy surely predates the Constitution. It's not mentioned in the Constitution, yet it is found in the Constitution. So there's really no rationale given as to what is this argument that just because something existed before the Constitution, therefore it is not part of the fundamental right to marry, especially when the same learned judge recognizes that, yes, there is something known as a right to a relationship. So that is what the majority judgment of Justice Bhatt says, that we can't create a social institution, but we can recognize that there is some kind of a bouquet of rights that exists in some amorphous umbrella called the right to a relationship. Now, I don't have to be a Hofeldian and a very positivist to understand a right has basically two sources: statute or the Constitution, statute common law stroke, statute and common law, or the Constitution. Now, obviously, when we ask for a right to marry, we start with the assumption that there is no statutory right. We're asking you to give us that statutory right. You have held that there is no right to marry under the Constitution. So what is this strange creature called the right to a relationship that has been recognized by Justice Bhatt? I wish he was on the panel. I could have asked him for greater clarity, but I possibly think that he himself would not be so clear on that one. So that's what the judgment has roughly done. In terms of the technical objections, well, the only technical objections other than waiving the Constitution and saying, well, there is a separation of legislature and the judiciary, and this act will be unworkable if you start reading words in and you are doing legislative action. That was a technical objection, really, that when it's okay to read spouse in a gender-neutral manner, but there are many other provisions under the Special Marriage Act which will not be able to be very easily resolved through a process of statutory interpretation or reading up or reading down. So that was the form of the technical objection. But I'll let you read that. But in my understanding is that a role of a constitutional court is, if it is tough and you can't read it down, you have to strike down the act. You could have given a suspended declaration saying that, yes, this act is unconstitutional. Let Parliament deal with the consequences of their own inaction in enacting legislation, not failing to enact legislation, recognizing non-heterosexual marriages. As long as there is discrimination, the court doesn't have cop out by saying, well, we won't just deal with it, let it just carry on somehow. No, you've got to deal with it. That is your oath of office, without fear of favor, affection, or ill will. That's your job is.
Just a few random thoughts now. The first is this, that I have absolutely no doubt that the most powerful court in the world is the Supreme Court of India. The Constitution bestows on it powers that no Constitution bestows on any other court in the world, including the powers of judicial review and how it can strike down a constitutional amendment, almost an unheard of concept anywhere else, how it can strike down law. Even in the UK, it was only in 1998 with the UK Human Rights Act, and to a very limited extent, the courts that could strike down law. So that, coupled with what Saurabh touched upon, the oaths of the judges are all in very, very clear terms, empowering them as far as judicial review is concerned. I don't believe there is any such thing as judicial activism. That's actually them discharging their duties. I know there are different views on this, but I believe what they do is solemnly to uphold the Constitution. Everything under it is permissible. Having a power like Article 142, which doesn't exist in any other constitution in the world, having a power under 144, these are very, very unique provisions which allow you to enforce your will once you're done with just merely adjudicating. It allows you to take things slow. And the Supreme Court has expanded its powers either when it had the spine to, when your father was Chief Justice of India, what he did for the environment of Delhi was fantastic. We were just discussing it this morning. There were competing interests. The 19(1)(g) right to trade of 170 polluting industries in Delhi. Rip up and throw them out if it's violating right of health of people. Right? It was done. Brick kilns were moved up. Buses moved from to CNG. That's really what we need outside right now, but we don't have it. Now, therefore, the court is a very powerful court. The court is being invited to give the same protection or the same rights that you've given a large part of the populace. Now, the one place where I differ from the petitioners here, and I differ from the petitioners in the 377 case, is the way that the issue is formulated, right? There's a community formulation in what is a pure legal issue. 377, for example, was dealing essentially with actions against laws of nature, which could equally apply to a heterosexual man wanting to have anal sex with his wife. But it became a queer community petition, viewed as a queer community petition, which is why the earlier JS Singh we led judgment said, oh, it's a minuscule minority. Thankfully, in Puttaswamy, they overruled that kind of a shocking remark. Even here, what is the problem? The problem is that the queer community has come in and said, look, you are enveloping those people with this cloak of marriage, and from that cloak, they get certain rights. The problem I've always had is cloaking it as a community issue. The question really is marriage. What they did is they sought the protection of that cloak. My question is, a heterosexual couple who are unmarried and don't want to be married, do they have the protection of that cloak? They don't. Now, if you make this a community issue, I hope you don't mind. I just feel that this is something that makes, if you make this a
judgment of 5, I don't mind anything.
if it's made a community issue where a group comes and says, look, I need to be under that cloak. Suppose the court went the other way and said yes and gave them that protection. What about the guys who are still outside the cloak, who are not the queer community, but who are not people who want to get married, and who still want to adopt, who still want all the other civil rights that you asked for, nomination, banks, insurance, whatever else, right? It didn't deal with that. So viewing it from a community lens, I mean, there are some cases which need to be viewed from community lens. This, I thought, perhaps is not one of those. Now, having said that, once they do come, whoever they are, and they come to you, and they are clearly a numerical minority in the country, the Constitution tells you that you are their sole guardian, because Parliament is not the sole guardian of the minorities, they cater to the majority. The minority, that residue, is left with the Supreme Court to guard and the High Courts to guard. And somebody comes to you with this plea, it is your bounden duty under your solemn oath to uphold their rights and to give them the remedy. It is not sufficient to say, sorry, actually, because we don't think there's a fundamental right to marriage, goodbye, we'll leave it to Parliament to deal with it. The minute you found the problem and you know that it's a violation of the Constitution, that you give certain people these protections and other people don't get those protections, it's for you to turn to the government and say, look, what are you doing? Let's consider a situation before the Special Marriage Act. A Hindu and a Muslim want to get married, heterosexual. What do? You don't have a law, right? So how do they get married? Where do the rights come from? The state says that I have to make a law to give you this recognition. The state decides, and we cede to the state that right to decide. I have a problem fundamentally with the fact that the state decides that marriage is linked to A, B, C, D, E, F. Left to myself, very honestly, and I can share this with you, my wife was also a lawyer of the court. We were dating for a while and we actually thought we wouldn't get married, but then we wanted kids. And we know how society judges kids, which is why we got married. The insistence on marriage as an institution is a fundamental problem for me. I think just insisting on marriage and forcing all of us to go under that cover and try to get those rights, that's where I think the court got it completely wrong in saying that there is no fundamental right to marriage, because they were not attacking marriage. They were saying, fine, there are these laws, but it doesn't cover the rest of us. You can't say that there's no fundamental right to marriage and yet make law after law after law for Hindus, Muslims, Christians, special marriage, and say, but not you lot. For me, that's patently discriminatory, and there's no question that the court can't then say, oh, there's no fundamental right to marriage, because if they had recognized the fundamental right to marriage, then it's against the state. Then you have to enforce it against the state. Then the state has to do something about protecting the rights. So the only cop out to adopt what Saurabh said was for them to say there's no fundamental right to marriage, which I find odd, considering that you've said the right to watch cricket is a fundamental right in Cricket Association of Bengal. Yes, the right to sleep, the right to family, whatever that means. Without marriage, we're going to have illegitimate children, because that's the phraseology they will use, and say you have rights, but no, not marriage. So, and this pre-constitutional thing also makes no sense to me. Women have been getting pregnant before the constitution, yet the state comes trundling in and says, 28 weeks, 24 weeks, 24 weeks. Why? Because you're trying to serve a larger purpose of no gender determination, etc. So for that, you find yourself some human purpose that you have to serve by statute. But for this, you don't. The Supreme Court should have unanimously recognized, if not the right of marriage, the right of the entirety of people who are not married, in whatever manner. The right to civil union, which is where he made a half measure in his minority judgment, and gone further and laid down guidelines and said that until law is made under Article 21, this is the policy, that deputy collectors, blah, 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 these are the people who will. I came late because he was giving one very detailed order in another matter. I'm saying same thing, spend 3-4 days, give details, chart it out, and say this is what is going to apply till the law comes.
That's that's very interesting. That the bit I was a little confused about this question of community not being centered on this question, as opposed to a larger right being centered. And arguably, and I think the way Saurabh has framed it as well, there was a legal question in that framing, which was the supposed distinction between freedom and discrimination. There were these questions about impact, which was what happened in 377 as well. But we know this, and I think what you have to say will be quite useful as we go to the next leg of the discussion. So, yeah.
Just a couple of responses to what both of you said. I think in terms of just framing the question as a fundamental right to marry, that point has been articulated after the judgment, with many feminists coming forward and making a claim for relational equality, as opposed to elevating marriage to the only form of intimacy worthy of protection. And I think that's a path that's also being explored. That was in this petition as well. There was a petition by a group of queer trans feminists who asked exactly for this, independent of marriage. Again, flowing from that, just looking at some of the directions where they spoke about how discrimination specifically, when it comes to benefits that flow from marriage, the court asked the state to address that specific discrimination and ensure that specifically for queer trans couples, those benefits are available. And I think the ones they pointed to were largely employment benefits, Provident Fund, ESIC, etc. Also, just coming to the review petition that has been filed, a lot of the arguments that you made, Saurabh, are actually reflected in the review petition, the points that you mentioned where the court's gone wrong in its assessment of things. But given these developments, I largely wanted to now shift to the way forward. I think what was very interesting for me was that after Suresh Kaushal came out, I was in law school and I witnessed unprecedented mobilization. And I saw a lot of allyship, which I hadn't seen before. You see the queer community come out like never before, and you see a lot of people speaking up for the queer community. And I wonder if this is a moment like that for us, if it's a post-Kaushal where we see activism suddenly go up, because I do see these conversations about mobilization happening all over the country. So one, with respect to that, and second, with what we have, barring Supreme, judgments like NALSA, judgments like NAFTAGE, a lot of decisions coming from high courts, which are fairly progressive as well. How do we use what we have to push for further expansion of rights, beyond marriage as well? What do we do with what we have now? And are we expecting a post-Kaushal moment where we see people suddenly come together and mobilize and speak about these issues? Sorry, if you could start with you, Akkai, and then Gopal.
Sure. One of the reasons that the review is very similar to what I argued just now, because I settled the review petition. So it's not surprising. But it's interesting, and maybe I focus a little less on the legal way forward. I'll touch upon it, and maybe then Gopal can take it. I really feel that I should speak maybe also as a queer person who is, other than just a lawyer, increasingly, as I call myself, an accidental activist. And I've seen the anger in the queer community, not just within the queer community, but all our friends, relatives, people who know us peripherally or intimately. There is deep, deep anger. I think when the hearing was going on, a lot of people questioned the concept, as you people are entitled to question that why are you going after marriage is a patriarchal institution? There should be recognition of a living relationship, or have a non-natal family and certain protection of rights. Why are you going after marriage? And there was a very interesting academic discussion that was going on with the queer community, because there was a feeling that you're going to get this in any case. It's when you didn't get it that it felt like a slap in the face. Is that when the queer community woke up and said, hang on. All this while after 2018, I thought, I don't have marriage equality, but otherwise I'm an equal citizen in this country. I think all of us harbored that misconception, it seems, because that is what it has proved out to be, a misconception. And once the reality of that has been shown to the queer community, there is anger. I don't think I've spoken to a single person who says, well, this judgment is all right, and that's fine. We've lived with this and we carry on. It's fine. There is palpable disgust and anger and a desire to do something. And I can't fully reveal the details. Maybe speaking to certain other people, we're planning multiple things. Legal, again, as I said, I'll let Gopal argue his legal perspective. But really, from perspective of activism, I think you're right. This is almost like a causal moment. There is greater allyship now in the media. We have to use that. We have allies everywhere, but unfortunately, the one place where the court has told us to go is Parliament. Right? We don't have allies there. So that's another thing we have to now do, is to build up a political momentum, make queer issues political issues. Now, we may be a minuscule minority, but I think the learned judges obviously don't go on certain apps to see how little numerical minority we are. We are not, just 5 people sitting in the basement of Vidhi having a discussion. There's a very large number of queer people outside in India. People of my generation, very few, because we were scared. It was not easy for us to come out. But in the younger generation, that's not the case at all. You go to universities, there is freedom. So there's a very large number. And we have to use that anger to mobilize the young. So let them speak. And it's always revolutions come. And I'm not saying overthrow the government, because, I'm not. It's ED season. But a social revolution will happen, I think, with the young. And I see that in the colleges and schools that I go and speak at. The freedom with which people live, I don't think they'll be content to just take this one line down. And we have to capitalize on it. And we plan to capitalize on it through multiple ways. Right? Legal. One thing I can say about I've quickly said I'll defer to Gopal, but I'm a lawyer, so I can't just defer to anyone. I have to speak, right? So one thing we're planning to do is that even if review fails, we've started that chapter that is now out of our pay grade. The judges will decide whether they want to review the judgment or not. But the judges have also said that you can come back to us on a case-by-case basis for individual rights. So one course of action is to go back for various rights and build up a corpus of jurisprudence which will give us those individual rights. Another rather more sneaky thing that we think we can try is to have the process of interpretation of a judgment. We've seen multiple times when a 9-judge bench, 11-judge bench has been interpreted by a 3-judge bench to say something quite contrary to what you think the 9-judge bench said. So given the ambiguity in this judgment of Superior, maybe a 3-judge bench at some point will come and clarify exactly what it means. So that's another way forward for us legally. But I think it's time, you're right, that we get out of the courtrooms and also start fighting on the streets. And because really, judges sometimes follow public opinion. And that's what happened in Kaushal till Navdeep Johar. I think the freedom that NAS gave from 2009 to 2013, the way the people had come out and tasted that freedom. And when Kaushal said, no, no, back into the closet you go, there was again that palpable anger. Society changed. So when in 2018, the judges were asked to decide upon decriminalization, they felt, well, that's something that's okay. So maybe we need to show to the judges now who will decide the review, or some future judges who will decide this issue, that it's okay to decide in favor of marriage equality or rights to the queer community, or at the very least, it's certainly not okay to decide against it.
Okay. Yeah. I think the strategy is sound for the large part, but a couple of things that I would add. One, on your review petition, I think it's fortunate that you have the precedent of Sabrimala, where after the court's final verdict, after the court's final verdict, when the review came up, the bench composition had changed. And I think those are practicalities that you've lived with. And the bench then decided that they needed to revisit this entire issue. And the question whether in a review you could refer it to a larger bench came up, and it was decided. And they referred it to a larger bench. So I would not be surprised if within the next 14 months you had this review referred to a larger bench. I would not be surprised. I would be surprised if the review is dismissed. I would be surprised. On the main judgment, it's a little different, but on this, I would be surprised if they dismiss. And fortunately, like I said, you have a precedent now you can use. That yes, you can refer it in a review to a larger bench for decision. I'm not optimistic about Saurabh's interpretation idea by a smaller bench. I'm not optimistic. I mean, it may happen, but I'm not optimistic about that happening. I had misgivings immediately after Navdeep was delivered about the lack of organization and the lack of the fraternal feeling among the queer community in prosecuting Navdeep, which I saw now. And I saw that they were much more organized. I saw a huge cleavage after the Navdeep judgment came. There were a large number of people within the community who felt that, look, this small bunch of Lutians alike, elite who are taking this case forward, Kalmakin gang, etc., etc. While the large assemblage across the country are not part of this. And I think in the period after Navdeep, the fact that, media adulation, etc., etc., who are talking about all themselves. I think that created an unnecessary cleavage. I think leaders of this very vocal legal queer community, which includes Saurabh, must take it upon themselves to be more inclusive, to ensure that they go university to university, giving up very lucrative briefs in court for the purpose of the cause, and to muster the numbers and get more people on board so that the court gets an idea that, look, this is not something to trifle with. Also, in Navdeep, the big advantage was the Puttaswamy judgment had come. And Chandrachud had very clearly, on day one of the arguments himself, when the 9-judge privacy argument was on, said that, look, wouldn't privacy include sexual choice? So that was the bell that got ringing. Augure was part of the batch of lawyers who argued there as well, which made the court specifically say sexual choice. So Navdeep is just a follow-up. A smaller bench is following what 9 judges said. So in fact, on that very day when the 9 judge was delivered, I was on TV or NTTV where I said, mark my words, this NAS review, everything is now academic. It's going to be 377 is going to be read down. So Navdeep that way had a kind of protection behind it. This one doesn't, right? It doesn't have any big precedent that can rely on and say that, look, I'll get into the door, I'll be before a larger bench, but you still have to bang out on the main point. And there, I think it's necessary for a slightly more inclusive, perhaps include people from outside the queer community also. Like I said, it's a question of human beings not being required to marry under statutory law to enjoy all the full assemblage of rights that are available to them. So otherwise, I think the strategy and everything is sound. I think it's for the community to take it up. I want to say one thing where Saurabh mentioned how his generation were a little hesitant, it didn't come out, and the numbers are larger among the youth. I think that's very true. But I think a large amount of credit there has to go to the parents and your family of the young people. Kind of support gives. It was it was unheard of when I was younger. I was fortunate to be part of small cohort in National Law School where we had the first gay rights seminar ever on a law school campus, led by a guy called Kabir Bhavekante, Sanjay Bhavekante, in 1996, December 96. And I remember it was a 3-day seminar where members of the queer community came from across the country to the university. And we were shocked at the kind of reception they got from so-called National Law School students who you thought would at least be tolerant of different views. They were staying in hostel rooms and stuff like that. And we had to diffuse a situation where one of us, a group of our students, very right-wing, vibrant, rabid, right-wing students, refused to let them drink water from filters which were in a mess. Right? And I think many of the community from, at least my contemporaries from National Law School, Adinara and etc., had seen all that and have been part of the community and seen part of the fight. I think the fact that now we've reached a stage where thankfully I hope that kind of stuff, at least in urban centers, isn't happening, means that there is definitely a greater acceptance. But I'm not optimistic about the legislature stepping in and doing stuff. I don't think the Overton window is there yet for that. I think we have to move courts, and I think there's a very strong legal ground for the good judges to understand and embrace.
Finally, Akkai, just wanted to turn to you about how do we go forward. Also, specifically the challenge to the Transgender Persons Protection of Rights Act and the directions in marriage equality about medical intervention and how that impacts that petition that you're also a part of. But given you're in the movement and you're talking about housing, employment, discrimination, and you mentioned a lot of these things in your letter to the Prime Minister, if you could tell us about the conversations that are happening about the way forward and what do we do next?
I totally want to endorse what these two gentlemen has, put out there, perspectives or views is concerned. I want to totally endorse it. The second thing, I think Indian sexual minorities movement is set to fight against all forms of social exclusion, especially Sushil Kumar Modi, who stood in the Rajya Sabhas of the Indian Parliament and who said this is something called the urban elite issue without knowing the importance of the existence of identities, sexualities. It's so disappointing. I think in that context, India is set to fight that sort of homophobic, transphobic, all form of phobic mindset to fight against that perspective as a movement. The third point would be we as an organization or as a movement, as a convergence, the idea of talking to the various social justice movements, talking to the constitutionalities, talking to a legislature, talking to executive, talking to a judiciary, talking to a civil society movement, that shall continue. The third thing is also to build a consensus and solidarity movement for this country, knowing that the importance of this country's culture and tradition. Without movement, nothing is going to happen. The fourth point would be about how do we translate the constitution language or the language of judiciary to the common people's language. Until we translate this language to the common people's language, it is so difficult for me to, like a person like me to understand and, critique on these judgments. That needs to happen as the priority. I think the observations made by the Supreme Court Constitution Bench constituting a committee under the Cabinet Secretary of the Government of India, that we really want to engage in that process, number one. Second thing, it has also left to the state assemblies, to the state governments including the government of India. I think in the southern part of India, the movement has already begun to talk to these governments, to talk to the political leaders, to talk to the political movement. The fourth point would be about, I think the fifth point, would be about India can't be silent anymore. This is 21st century. I'm 39 years old. I should still enjoy my right. Saurabh, I think this age is for age and not for you. So till we die, let's keep fighting. Let's enjoy our rights. Let's talk about to uphold the dignity of people. Whether my law gives or not, that is secondary. But we should feel proud to be part of India. I think whatever happening across India as a country, that's our issue. How do we stand together to fight against all forms of thing? The final point would be to, as community activists, somewhere I felt that we didn't come together. If Akkai has gone to Supreme Court filing petition, somewhere I felt that I did a mistake. I didn't speak to Saurabh. I know as Saurabh also has felt that he has not gone and talked to the feminist groups before filing this. I think how do we also learn from this process of doing mistakes, and for future we don't do mistakes. I think with this, I still have hopes. The Ambedkar written constitution has given us much more hopes. My country's system of justice, she'll be accepting us very soon. Until we occupy the positions in the system of political representation, Saurabh should definitely become the country's judge. That's what the whole movement is waiting for. Like that, in each and every aspect of the community needs to occupy its spaces, positions to lead a life with dignity. Thank you.
Thank you so much for that, Akkai. And on that note, we'll be taking questions from the audience. And if you're joining us online, please do share your questions over chat. Any questions from the audience here?
Hello. Hello, my name is Shreyoshi Tirabdar, and I'm a panelist student from Miranda House. So first of all, thank you so much for such an insightful and thoughtful session. So my question is, as mentioned by Mr. Gopal, that 370, Article 370 was abolished because it might be in the interest of the government and something that the government also promised. However, on the other hand, if we see the state denied to provide basic rights to its citizens, like right to marry. So how do you think it impacted not only the democratic fabric of the country, but also the privacy of an individual?
I'm still trying to unravel the link there. But what I understand from your question, because 370 was an issue where the government has a stake and it's a direct challenge to a governmental action, on which the court has reserved judgment, and we won't discuss that. But if you can just clarify the last bit, I couldn't get that exactly with reference to privacy. As a question, I'm sorry.
So my the gist of the question is that how it actually impact not only the democratic fabric of the country, but also the privacy of an individual.
This decision.
Yeah.
Decision. Well, I think it all boils down to that central aspect on which they are all ad idem, that there is no right to marriage. Look, if the petitioners are arguing that since a recognition of marriage has taken place, then I think it's important to locate where the right is that the petitioners claim that they have. They have located it, from what I understand, apart from other places, in Article 21 and with reference to the right to privacy. Now, it would be odd for the court when 9 judges sat together and decided that there was a right to privacy and it had many hues to it, which included, like I said, sexual choice, food, and everything else. For you to say no, but marriage is not part of that, because marriage includes within it sexual congress, it includes within it all types of intimacy outside of sex as well. Procreation. So it's very difficult for, I would think, for any bench, even of 5, to get around that and say that privacy is a right you have, and privacy of what then would be the next question. There's, of course, privacy regarding what of medical interference, of body, of space, of communication, different hues of privacy. It was argued, in fact, by me, that it would be difficult for the Supreme Court to say all types of privacy can be protected, because we have old judgments of the Supreme Court which say fundamental rights cannot be waived. So if fundamental rights cannot be waived, the next time you need a kidney transplant, for example, you can't perhaps sign off saying that, look, I'm giving you consent, because you can't waive that right. So the court was invited to give a nuanced judgment in privacy, which they did not. They went whole hog and said all aspects of privacy are protected. Once they've done that, for a smaller bench of five, to make some kind of artificial distinction, I'm not sure if they even dealt with this issue of the 9 versus 5, but for them to make this kind of distinction that marriage for some reason is not a fundamental right, because all aspects of marriage are effectively aspects of the privacy of not one person, but two people together, right? So I feel that that's perhaps where there is something to be argued and pressed going forward. I feel that there is a dichotomy, and I don't think the court has dealt with it properly. Does that answer your question? Because I'm grappling with whether I understood it properly. Okay.
Hi, my name is also Srishi. I work at Vidhi. I wanted to ask 2 questions, and I think that has partially been spoken about by Akkai also. But because the judgment and the way it was delivered doesn't make it super clear what's the majority, what's the minority, what stands ratio, etc., etc. The Chief Justice also recognized the constitution of a committee to deal with banking, advanced medical directives, and where queer people's rights come in that sense. Is there any teeth to this, given that his judgment was in the minority, and how do we read that? Especially given the Solicitor General, if I remember correctly, had already committed to doing this anyway. A, is that committee going to be set up? B, because there is no guidance to the composition, the timelines, etc. Do we even trust that committee to do something that will be in line with the community consultations, etc.? And the second thing, which also Akkai mentioned about community consultations, and Namrata and Saurabh spoke about post-caution. The difference during post-caution was that, even when we were in law school, we were also, going through FIRs on 377 to figure out, to tell the court what the actual impact of 377 was. So now, what is the way to come together, and what are the things that are being done on ground to maybe reassess strategies, to maybe kind of tell the court and go to them with more clear thoughts and more thoughts based on consultation and evidence? Is there something done in that regard?
As regard the first part, I think that was just an attempt during the hearing to have a cop-out. I have used that word once before, but when the solicitor made the recommendation that I have a committee, it was at a time when he felt, or the government felt, or whoever came up with that suggestion felt, that the hearing was going in a particular way, right? And to retrieve the situation, they said, why do you decide all this? We just have a committee. Now, of course, the tables have turned when the judgment comes. And now it's, I think, a subterfuge, this idea of a committee, because, as you said, there's a lack of clarity as to who will form part of that. Second, the committee's mandate stated, I was in court when the solicitor made this submission, was that it was purely administrative in nature. So can only come out with guidelines and ideas and tweaks to rules to enable a queer couple to live together, or indeed not by queer couple. Gopal rightly says, any two people to live together. But a lot of the discrimination that exists is legislative. Okay? And that neatly takes us to the second part of your question, is while 377 FIR, it's clear and evident as to what the form of discrimination is. The discrimination on the simultaneously subtle in the case of a non-heterosexual couple or unmarried couple, I should say, but probably in another sense even more direct. It's subtle because married people don't understand and feel it because they have those rights. You don't understand the absence of a right till you don't have that. A queer couple, on the other hand, has a daily way of living with that absence. And that's what I foresee happening. Individual people coming out with their problems. So, for instance, if I have a partner who finds it difficult to get a visa and we live together, if two people live together, they can't have a joint bank account, not because you can't open a joint bank account together, you can. But if a person A puts money in that bank account and person B spends it, and A and B are not married, that would be taxable in the hand of person B, right? Now try, so those are actual problems which will come highlighted through the other petitions that probably will come up slowly. But how does the community come together at this point of time? And that's very important. Part of the problem is the diversity of the community. We are fractured at multiple levels. There are intersectionalities in the queer community the way they are in multiple other movements, the feminist movement, etc. But I think for that, we have people like Akkai to look to. I think the way the trans community has mobilized itself and done such amazing work, we as the rest of the queer community need to learn from that, really, and maybe ride their coattails a bit. So whatever they've done, we have to take it and just ramp it up a bit. We will need to form organizations, and that's one thing I was doing earlier, and Gopal referred to it, that maybe we should have all spoken to each other before we file a petition. But how do I reach out to someone? There isn't no one umbrella organization where I can go and say, well, this is what we plan to do, what should we do? And if I pick up a phone and speak to one friend of mine, I'm then ignoring a lot of other people who also have a right to access to the court, who may not be known to me. I'm then privileging privilege, right? So what we need to do is having some kind of an umbrella organization. We're working towards that, but creating a community grouping is not an easy task. But that doesn't mean we just give up. So we have to keep on fighting and trying to do it. So that's the long and the short of it.
I just want to add on one thing regarding Chandrachud's directions of the end. You're right. It's difficult to call a ratio on that because I don't think the other judges disagree with that. So it's worth definitely a clarification application. I remember about 20 years ago, we did something similar in Must be.
Yeah, sounds good.
Okay. About 15, 16 years ago, in a reservation case, which was 5 judges, they had ruled against us. And the clarification that we filed went back before 5 judges. One of the judges had gone and they got somebody else to replace. And we asked for clarifications on 2 things because it was Ashok Kumar Thakur is the name of the judgment. It's about reservations in admission in education institution. Because there were multiple judgments as there are here, there wasn't complete cohesion on 2 points about cutoff marks, which relaxation and something else. And the court eventually accepted our point. I remember Justice Balakrishnan, who was the Chief Justice, had authored the majority judgment. And then when he said this has already been decided, we said you're in the minority on these 2 points, right? It's similar here because if somebody were to say, look, the others haven't agreed, there are judgments from the 60s and 70s which say that if 2 judges or 1 judge opines in a constitutional bench on 1 point, and there isn't contradiction, this could be relied upon. Not that it's the ratio, but it could be relied upon. But if a clarification were to come, especially because the Supreme Court is a court of record, like the High Court under Article 129. So being a court of record, it has recorded Tushar Mehta's statement on behalf of the government, which binds the government. So at the very least, this could be something, but of course, Saurabh and all the others in the community will decide whether this is good strategy or not. Because when you're going to review the entire judgment, would you also clarify it? Because that means you're accepting the judgment as it is while at the same time questioning it.
Akkai, if you could also respond to Shreyasi's question.
No, I think it's an ongoing process. As community, we are going to stop our activism as allies who are part of the system of majority. You should not speak on behalf of the movement. We want voices from a cross section of society to speak. When I say cross section, that includes the religious, entities or institutions, the political movement. And as Saurabh was mentioning about the queer/feminist movements should speak about this. Until you empathize with the movement of, the most neglected society, I think it's also so disappointing here. No one is speaking on behalf, only fighting for myself or fighting for me, fighting for my community. I think this society is something called messed up, with so many issues, so many fractions. If you go back to Constitution Bench judgment, there was differences. But no one took the bold stand, yes, we should support and this should be done. I think somewhere court has missed this opportunity. Yeah, that's what I would say. So please speak on behalf of us. Yeah.
Hi, my name is Aditya Bhattacharya. I also work at Vidhi. My question is, when the hearings commenced, the court very consciously chose to restrict the canvas to the Special Marriage Act and excluded the religious personal laws from its scope. And arguably, these personal laws discriminate even more than the SMA on the basis of gender and sexuality. So the question is, where do we go with respect to these personal laws? So, for example, is the Uniform Civil Code a potential answer to the issue? The Parliamentary Standing Committee on Law and Justice, as well as the Law Commission, is seized with this matter right now. So is the queer community planning to engage with these bodies and with the UCC as an idea in general?
Yeah. Well, look, the queer community will, of course, engage with anyone who engages with us. It's not as though the parliamentary committee has reached out to any member of the queer community to ask questions about this. What's interesting is, in the frame of the UCC, other than is the Ranjana Desai committee report that is happening in Uttarakhand just now. I remember reading an article about 6 months ago by Elizabeth in the Indian Express that Uttarakhand is also coming out with a UCC of its own. And one of the recommendations there that seems to be on the anvil, because they invited objections, was the rights of a queer couple or a live-in relationship, not necessarily queer, a live-in relationship. So that undoubtedly could be one way forward. My voice is so loud, I don't realize when it's on or off.
No, I think it's only for the Zoom people.
Yeah. Right. So for the queer community, we will engage, of course, with the UCC. Is the UCC the way forward? Well, the way the Special Marriage Act, which was a UCC of its time, excluded the queer community. I don't know what the text of the legislation will be when the UCC or it actually comes out, the draft. Let's see what the draft says. Multiple people are working on drafts. I know Vidhi is working on a draft. I read some of the work, excellent work that you've done. I know the people in Kerala, the Kerala government is looking into it as well. But UCC, of course, comes with its own set of issues. And it could be inclusionary, it could be exclusionary. It could be inclusionary or exclusionary. We'll have to see. But in terms of engagement, the way, of course, we must engage with as many statutory authorities as we possibly can, whoever will listen to us. The question is, how do we get access to that? And for that, we'll have to build a political movement, make ourselves heard. It really comes back. It's, the chicken and egg situation, really.
If I can just come in that Uttarakhand point. And this was just an informal conversation with one of the members of the committee. This was a while back, well before the judgment. Yeah, I think it's definitely the mic and not us. I think he said something that was very interesting. There's no way of getting funding for it. Yeah. We can't even afford some mics. Yeah. Maybe you guys can fund this. But I'm just going to let this go because this is not. So he said something that was interesting. This member of the committee, completely informally, he said that they had done public consultations in Nainital, Dehradun, and in Nainital and Dehradun,
there was obviously this view that we kind of expect that this doesn't exist in our, it's talking about queer couples, this doesn't exist in our society as this is a disease, and we can't deal with this. But when they went to remote Pithoda, the folks there said that ये तो हमारे society के हिस्से हैं, ये तो होता है, पता है, कुछ ही नहीं दीजिए. Okay, and they said that there was greater reluctance, the point you were making, Gopal, on live-in relationships than same-sex marriage. And in fact, they were going so far, and this was an informal conversation, and they said that they would be okay with even recommending same-sex marriage, but not so much for live-in relationships. But there were two judges of the committee, that committee, who were not okay because they wanted this judgment to come. And so I think that there is some merit to thinking about engaging with legislatures, particularly in state governments, because there is a kind of much more rooted closer to the ground. And especially given that this is the kind of reaction that you get, I find it very surprising that the court ruled that there is no, at least that there was no declaration on a right to marry. And I find that, as in all the judgments that you quoted about the right to family life being a part of Article 21, as in the right to marriage, marriage is a fundamental unit of society in India. I don't think we've reached this kind of postmodern society where without marriage we are ready, and that's a different matter whether it's a patriarchal institution or not. And this idea about marriage predating the constitution, as an is I mean, the dignity predates the constitution, right? So what? The constitution can't recognize dignity. I mean, and I think it's perhaps, sorry, I don't know, this is a bit of a comment, but it's perhaps too late in the day for the Supreme Court to now say that we can't recognize a right which has so many positive obligations on the state. As in, again, this is an argument which may have worked in the Gopalan era, but doesn't work today when you have recognized a whole range of rights. And to just end, I think, Gopal, I agree with you that we were all thinking that this is perhaps part of some swap. But I guess we all thought that this was a swap which would go in favor of the petitioners because it was, and when something like 370 would go in favor of the government, because then everyone would be happy because the court knows which matter matters more to whom. But now that the swap has gone the other way, maybe Akkai is right that it is time perhaps for a person belonging to the queer community to become a judge in our higher judiciary. You, somebody else, I mean, maybe it's a little late in the day for you now, it's gone for a very long period of time. But I think symbols matter. And I think the reason as to why we were talking about acceptability amongst parents and so on is because now it appears more mainstream. And so otherwise reasonable people would perhaps think that this is now entirely mainstream, and so it's something that we can support. So I do think that, I hope that there is a swap of some kind that does come out.
I just, on this judge point, I find it curious, I find it quite unbelievable that in all the thousands of judges that we've had so far, we haven't had a queer judge.
No, I'm sure
Question is, so what I'm saying is, of course, it would be great if we were a judge. I would be relieved of one court where I don't have to appear and get scolded. But I'm sure, can you imagine the impact if one of the Supreme Court judges came out and said, I'm out of the closet? Can you imagine just the impact of that? Because then what they have done in these 5 judges is not to somebody who was down there, to somebody up here. That's right, with them. And I think it's important, therefore, for these groups to, get together and move and empower those who are still sitting in the closet and not coming out.
Are there any other questions? I think we can take one more. Okay, that's all we have then. Just one more question.
I'm Kanav. I'm from the Vidhi Center for Legal Policy, and I have a question for the Saurabh or Gopal. It's about taking the issue to politicians. So I have a concern about that. I think Saurabh, you spoke about now taking the issue to the people and trying to see what people have to say about it. So my concern is that if we politicize this issue, we already know it's political, but if we politicize it further, what if at the state level, certain hostile state governments decide to enact bans where they prohibit same-sex couples from obtaining government schemes, for example? And if those bans are, let's say, challenged at the High Court, let's say some high courts support those bans. So then what happens is you have a bucket of case law, which never existed before, which upholds these bans. Some high court judgments may not go that way. So I'm seeing this with the MTP Act. You have a clear abortion act, but post 24 weeks of pregnancy, the different high courts are taking different positions, even though the law is pretty clear about what the exceptions are. So this is my concern, that it could completely go the other way. And we did see some state governments that opposed marriage equality, and given the fact that there is no fundamental right to marry, there's actually nothing, from what I understand, there's nothing stopping a state government from banning same-sex couples from marrying, getting married, or participating or being eligible for government schemes in their states. So what are your thoughts on this?
Well, so what you're suggesting is that since the right to marriage doesn't exist, either two things can happen, and they're both plausible, of course, if the issue is politicized. One, that you have an explicit exclusion from the right to get married, as happened in the Defense of Marriage Act in the US. Right? So that's happened. We have legal precedent for that, which came from the court. And second is a specific exclusion from governmental schemes. Now, the latter, as far as the latter is concerned, people are excluded already. That will make little practical impact. But even to that extent, there's a precedent for that in the case of a judgment called Romer and Evans in the United States. But as far back in the mid-90s, 96, I think the judgment was, even before marriage equality had happened in the US, even before Lawrence versus Texas had come, which was decriminalized homosexuality in 2003. That in Romer and Evans, the state of Colorado passed a law, and I'm just giving a pure legal answer that may well happen. Is that why I'm not too scared of that? It's a risk I'm willing to take. So the state of Colorado passed a law specifically excluding, as you said, same-sex couples from access to government schemes, and cities were prohibited from giving specific and protection of anti-discrimination laws. And that was struck down by the courts in the US fairly easily, even, as I said, without there being Lawrence versus Texas, Obergefell, etc. Because that is a case of very obvious hostile discrimination, and that's something that won't even stand scrutiny, I think, under this judgment of Supreme. Right? So Supreme says you don't have a right to marriage. Sorry. So Supreme says you don't have a right to marriage, but you have this right to relationship. So I'm not too concerned about that. But your former point about the political impact is not political impact just by state passing legislation, which could be discriminatory. There could be an attempt to rile up people against the queer community, right? We see an instance of that when the referendum took place in Australia for recognition of marriage equality, that there was an attempt to polarize society against the queer community. And of course, if you are trusting the political system, then you have to go whole hog. When we file a case, we don't always think we're going to win. This one, we thought we had a good chance. We didn't. So you have to have some faith in the organization, entity, etc., that you engage with. I don't think in India we are at a state of such hatred that there would be open hostility towards members of the queer community. There is discrimination. There's a problem, right? But that kind of backlash that you are worried about, I think that is probably not warranted. But I could be wrong. But we don't have anything just now. If we don't engage, then what's the alternative? You carry on, status quo. That's okay maybe for me when I have so much other stuff. But it's not okay for a lot of people who need these legal protections. It's not okay for a lot of young people who don't see why they don't have it. I've made my peace with this. A lot of young people have not, they should not be asked to. Simple as that.
If what you said comes true, it's perhaps an excellent thing, which means that you're now perceived as organized enough and big enough to pose a threat. At the moment, the fact that they don't do it means they think you're irrelevant. This hard facts, right? For 10 years, we've been fighting this pollution business. We've had organizations, blah, blah. No political party gives a crap. They won't do anything. They won't come after you. They won't bring laws, etc. So the fact that they are going to take action against you means you're a threat. You're the Arvind Kejriwal who needs an ED notice. You cause worry.
All right, I think we have come to an end of this fascinating discussion. I will take this opportunity to thank the panelists. Okay, Gopal, Saurabh, thank you so much for coming here. I want to thank the audience. Please pat yourselves on the back for having made it here in these times. Those online, maybe not as brave, but maybe next time we'll see you at in the person audience.
Bring a guy to Delhi.
Yeah. I want to thank Namita and I want to thank myself for having stayed quiet for most of this discussion. There's so much to ask, so much to talk about, but it's the time is just like this. I don't want to end on this note. I would like to take this, all three of you, Saurabh, Gopal, and Akkai. I want you to be able to say very briefly one message, either to a queer person in the audience, and magically there's a queer person in this audience, there is, but to here or online, to a queer person, or to an ally, or to a naysayer. Very briefly, if you have a message, you could look at the camera, or you could look at the audience.
Message.
Okay. Okay, would you like to go first? Was that audible? Okay.
No, I want to go with the Saurabh. Please go ahead.
You're up, so.
Yeah, in the hot seat. Well, what can I say? There are many messages that I say need to be given to a member of the queer community. The most important of it, which is have faith in yourself, love yourself, know that you are loved, believe that you're capable of change, and believe that change will happen. Nothing is worse than a lack of optimism. A sense of defeatism that happens when these setbacks come. It's inevitable. But we have seen so much change in the last 10, 20, 30 years. Any young person doesn't know what it was growing up in the 90s or the 80s or 70s when Gopal was there. This country is innately a good place to be. And we have a just cause. And we will win.
Very briefly, to quote Dylan Thomas, rage against the dying of the light. Because you must know, and that's you can see from the people here, you have a lot of support, you have a lot of kindred spirit, and you have many people, not only from within the community, but outside. So you will get help, assistance, and guidance from quarters you would have never expected. This is a reverse. This may not be the end of the road. In fact, I'm pretty sure it's not. It's a long road ahead. So just be optimistic, get together, fight, and keep that central ideal of our constitution alive, fraternity. Just keep that alive.
Okay, would you have a message for a queer person in the audience? Something that you'd like them to know?
I want to give one statement. Okay.
Okay, yes, please.
Yeah. I think, so let's ignore the social construct and let's live for ourselves. Thank you. Judge not, support gender identity. Judge not, support sexual diversity. Thank you.
Lovely. All right, everyone. Thank you. That's it.
Thank you.